sorry about the technical delay. We just have one case on the docket today. Texas State Board of Social Work Examiners versus, I'm sure I'll mispronounce Uniacut name, but you know who I mean. Both sides ready?
Yes, Your Honor.
We're ready for the appellant.
May it please the court. The parties present fundamentally different views of the Texas Constitution's impact on occupational licensing laws. Under the state's view, the legislature takes the lead and has the freedom to try different things to figure out what works best for the state, and courts get involved, if at all, only in the most egregious circumstances. Under the plaintiff's view, however, the Constitution ties the legislature's hands, and courts have the final say about whether any particular standard is too burdensome as applied to any particular person. And that gets it backwards.
Could we take just a little step back to something that's maybe a little bit more pedestrian?
Sure.
What is our standard here? What is the bar that has to be cleared?
In respect to the substantive due course claim?
Yes.
Yes. The Texas Supreme Court has actually identified a couple of different standards.
Or with just respect to like plea to the jurisdiction 91A.
Oh, in that sense, they have to plead a claim that is not facially invalid. And so what that means is if you take all of their facts as true, would that result in a victory for them at the end of the day? Or has the law that they alleged simply not going to ever work in their favor? And so that's our position. Even if you accept the facts that they say, we think those are policy arguments that the legislature has already considered, and that the legal arguments will not result in a facially valid claim ever. So it should be dismissed at the plea stage. If you want something more specific, you can look at the Malk case, which says that facially invalid claims do not present a waiver of immunity under the UDJA. And in a footnote 9, I believe it says you consider the merits to that as far as you need to figure out whether or not they should be allowed to replead on remand.
I hear you on the Constitution, but the Texas Supreme Court's had a couple of chances to say what the answer is, and they take little bitty bits here and there. So I'm disinclined to take, oh well, here's all the answer to all. Let's just. What about in this case? I mean, for instance, on can you be a social worker without being licensed, either working for a church or a nonprofit or something like that? I mean, does this foreclose your interest in counseling other people?
I would say it does not close your interest in counseling. It does foreclose your ability, this law, if you have the requisite felony, to be a licensed social worker. And in order to practice.
And the difference is?
To practice social work, to hold yourself out as a social worker, there are certain laws that require you to be social workers, to hold the position of a social worker. Can
you hold yourself out as a counselor or a therapist or a advisor of some kind?
Well, and thus, of course, you would need to be a licensed professional counselor or a licensed marriage and family therapist in those circumstances. And this isn't a case in which they're arguing that social workers shouldn't be licensed. They want to have these licenses. So it's not an over-regulation case in that sense. They're just arguing about one piece of that no violent felony standard as part of that license. So that's really the only thing that's before the court. It's not whether they should be licensed. It's not whether the other elements of that license are met. It's just whether or not this piece violates the Constitution.
This relates to the common occupation, stuff like that. I mean, there's a lot of paralegals that practice law because they know more than the lawyers they work for. Have been doing it longer, and nobody seems to have a problem with that. If they're setting up shop by themselves, yes, that's a problem because then it's obvious. But if they're just working with a group of people, nobody can tell, and often they're compensated pretty well because everybody knows what they can do. So I'm just wondering how much of this is about, I just want the diploma, the certificate on my wall, versus how much of this is my life's calling and I want to do, and I won't be able to do what I feel like I'm called to do. And
I would suggest that my opposing counsel might be better positioned.
I will. I'm going to. But I need to know.
And as I understand it, they want to become licensed social workers. That is their goal. And there are certain things that only licensed social workers can do. They cannot hold themselves out as licensed social workers. There are certain, I don't believe they wish to be clinical, so, well, one of them, I believe, Ms. Thompson may actually wish to be a clinical social worker one day, which is a step above a master social worker, and that enables you to diagnose and do things like that. Master social workers can perform clinical work under supervision, so there are just certain things that you do need the requisite education and experience to be able to do.
Is my understanding that the state's taking the position there's no liberty interest in becoming any sort of licensed healthcare professional?
Yes, Your Honor, we have at least staked out that position that there is not a liberty interest protected by the Constitution in becoming a licensed healthcare professional.
Are you aware of any cases anywhere that have held that?
The closest I have, Your Honor, is probably that Rivera versus Sonnenschein out of the third court that we cite. It's not about healthcare professionals, but it's about being an attorney. It says that's a privilege. Other than that, we have what the Texas Supreme Court said in State versus Lowe, which is we don't have to decide whether or not a medical license is a protected right. And so I don't know that that really has been answered under Texas law. So again, unlike Patel, we don't want to assume the existence of the right. We do want to hold that out and be able to make that argument.
If we were to take the trail that the concurrence and Crown Distributing laid out, suggesting this really needs to be examined and perhaps there are no liberty interests substantively, what's left? If there's no procedural due process, as you have argued, or the state, excuse me, has argued, on the constitutionality of a legislatively enacted statute, then what's left? Is it just an equal protection claim at that point?
I think it would be, yes, procedural, perhaps procedural due process, and then an equal protection claim. Now, obviously, we have preserved that argument in a footnote, but we have not gone full in on there is no such thing as substantive due course before this court. I think that is a question that the Texas Supreme Court probably needs to answer, given the things it has said about that in the past. But the other three options that Justice Young did lay out in his Crown Distributing concurrence, we have covered in our brief: the no protected right, rational basis, and Patel. And we think under any of those three options, our law does survive.
How many people are we talking about? How many people apply for the licenses annually?
The record doesn't reflect that, Your Honor, so I couldn't say.
I know, but I'm just trying to get, is this 100,000 people are applying or 10? Obviously, if the question is individualized inquiry, makes a difference.
Sure, and I mean, in the past, there was an individualized inquiry, so it's not a question that the state cannot pull that off. The reality is that the legislature believed that there were gaps in that process that were allowing unqualified people to get through, and this was one way they saw about filling that gap and just saying, okay, if you have been willing to use force against another human in the past, we're just going to say that this license is not for you. Now, that doesn't mean you can't participate, as we've pointed out, in the healthcare industry. There are the plaintiffs have participated in the healthcare industry already. They have helped people in circumstances that they have found themselves in. They can still become licensed professional counselors and marriage and family therapists. So that's one of the reasons this isn't an oppressive burden under Patel.
Is the question of whether a liberty interest exists, is that something that requires factual development? I mean, do we need a little bit of discovery to kind of find out more about what this entails?
I think it's a legal question, Your Honor, because it's a determination of what the Texas Constitution means when it says liberty.
Right.
And does that include this kind of thing?
But
So,
do we look at that without like having more facts about, kind of the situation on the ground when we're looking at whether a liberty interest exists?
I think you would, because when the court's interpreting the Texas Constitution, it usually doesn't look at the facts in a specific case. It looks at, what was happening in 1876, what kind of laws
But
they were
again,
enacting,
we
the
don't know whether
treatises.
it's 10 people or 1,000. There's just a lot we don't know here.
Yes, but that I think is still a legal question and not a factual question. But if we do just want to jump into Patel, there are obviously two tests. The first one Patel didn't really rely on, which is whether or not the purpose was rationally related to a legitimate state interest. And the purpose here, of course, is to protect patients and clients of individuals seeing healthcare professionals. The only time I've seen this argument really fleshed out is in the Live Oak Brewing case out of the third court, and they were talking there about economic protectionism and saying that that's not a legitimate purpose, but that's not what we have here.
So what kind of scary stories happened to engender this law in 2019?
The only thing we have is a little bit of legislative history that says there had been reports of, healthcare professionals injuring vulnerable patients. We don't have anything more specific, but of course the legislature doesn't have to wait until a certain number of people are injured before it can take proactive action to make sure that people aren't injured in the future. So there is no, go ahead.
Could you explain the difference in Patel standards being used versus just plain rational basis? I had some confusion over the briefing on what is and what isn't an economic provision and regulated field. Can you flesh that out for us a little bit?
Sure, this I think goes to our argument that you wouldn't apply Patel in the first place. And part of this comes from, it's going to be footnote 16 in Crown Distributing, where they said, we never actually defined what the interest was in Patel, so we just followed what the parties did and referred to economic interests and economic liberties. And so to the extent this is a regulation of healthcare and health and safety of patients, I don't know that the Patel standard really applies, but again, Patel is the only case we have on this. There's never been another Patel violation that's ever been found, and so we don't have a lot to work with. And so this is less about regulating an industry and more about protecting patients, and to me that meant there is some room to argue that Patel wouldn't necessarily apply.
Why do you think that is? I mean, why is it just Patel and then silence?
I don't know, Your Honor. I think Patel was just uniquely, if you read it, the state essentially conceded that half of the hours needed for this eyebrow threading profession weren't necessary. So, there was not an arguable rational relationship there.
It looks like the, optometrist. You can't get glasses, and that's why they cost $600, because you got to go to an optometrist. But you can send it to China, and they send you some glasses for $30. It just looks like, as they accuse us lawyers of, pulling up the drawbridge after you, making it hard to get into the profession. With eyebrow threaders, that to me, that's just so different from a social worker, for sure. May not be a legal difference, but how hard can it be? Maybe that's because I don't get my eyebrows threaded, but social work is a different thing, and eyebrow threading, this just looks like they're making these people take ridiculous classes just to make it less competitive. So there was clearly an anti-competitive thread in Patel. We don't have anything like that here, and I know I'll ask them the same thing. Sure. But this is not, we've got too many social workers. We need to do this because social workers are generally underpaid, has been my experience, and so that indicates there's more supply than there is demand. I find that hard to believe, but that's, there's no anti-competitive argument in this case.
Correct, Your Honor. And so I think most of the argument here has been on that second prong of Patel about whether or not it's too burdensome, whether this is an overly burdensome requirement. And we would argue that it's not. Obviously, the facial claim has to fail because it's not burdensome to ask people to not commit felonies involving the use of force. Most people haven't done that, so most people aren't going to be barred from becoming social workers. The plaintiff's arguments here are really, I think, largely in part about timing, the fact that their felony conviction occurred in the past, and there's nothing that they can do about it at this point. And that certainly makes it a sympathetic argument. But they can, I think, in terms of burdensomeness, unlike the threaders, there was nothing they could do in the cosmetology industry, essentially, without going through that process. The plaintiffs here can still participate in the healthcare industry in multiple ways, and they have done so. And so I think that makes this different from Patel in terms of the overall burden.
But doesn't Patel, doesn't that kind of show us the importance of the factual development, because there was a record in that case, right?
If the court believes that
there's a liberty interest.
Well, yes, and so I took my earlier comments to you about what the existence of a liberty interest, whether or not Patel has been violated. If you think that there can be a Patel violation, then yes, we would go back for factual development. But we believe that even the facts they've alleged, again, are policy arguments that the legislature is free to consider, and that this court shouldn't second guess, even under the burdensome test of Patel.
So just to understand what you're saying, if Patel applies, then you consider the individual circumstances of the plaintiffs themselves versus in a rational basis, you don't. Is that right?
If Patel applies sort of from the facial perspective, or as applied to social workers in general, then you would look at the impact of this law on social workers, whether or not it is burdensome for social workers in general to be able to comply with this law. It would be more of that larger analysis. They do have as-applied claims, in which case I don't think the court in Patel did an individual as-applied analysis. I think that's a lot harder and a lot more, I think that does really expand the court's role into saying, well, we are now the final arbiters of whether any certain person can become a social worker, because we get to decide whether any standard is too burdensome for that particular person. And so the court didn't reach that question in Patel.
If rational basis applies, do you compare the current statute to the one that existed prior to it, or do you compare, or you just look at the current statute in a vacuum?
Sure. My time has expired, if I could answer. I think you, I would say you look, not necessarily in a vacuum, because you do have to consider the existence of other things, but I'm so sorry. I would not say you compare the two, simply because that's something, it sounds like what the legislature does. It says which one of these is better. The question this court is answering is this statute constitutional? Now, that the fact that there are other options out there might be relevant to that analysis. You know, if this were the only way to protect people, then it's probably, you know, a lot more likely to be a rational basis. If there are other options, then maybe that factors into the court's analysis. But it's not a strict which one is better, because that is a job for the legislature.
Thank you, Ms. Klinsman.
Thank you.
Mr. Knight?
Thank you, Your Honors. May it please the court. This is a case about Catherine and Tammy who are unable to pursue their calling of social work. The state requires you to get a license to pursue social work and to offer social work services. It requires you to get a license if you want to use the methodologies that they learned getting masters of social work degrees and then help other people in Texas. This is a sorely needed profession. There is nothing in the record that explains why this lifetime ban was enacted. When the state's own licensing authorities were asked about this by the newspaper, they said their initial reaction was, oh no, and that they had no idea why this law was passed. Catherine and Tammy are simply asking today for an opportunity for a court to consider whether that 2019 law is constitutional. The state is arguing that the court has no jurisdiction to even look at that law, to consider the evidence, and decide that constitutional question.
And as I heard one legislator, one senator explain one time, when all you are is a hammer, everything looks like a nail. And so what they're thinking of is somebody, someday, who's got a terrible criminal conviction in their past, 20, 30 years of, and they get social work and they harm somebody, who's gonna get hung out to dry? Well, the legislators that didn't approve that, or the person, whoever the hearing examiner is. I mean, it's the same thing as happens, you see this all the time on the bail and the you know, releasing undocumented people. All it takes is one person and one bad apple, and you've got thousands of people that are getting approved, and it's a good thing they get approved, and it's good for society, and one person doesn't, and somebody gets killed, raped, or otherwise hurt. And that's when people like us lose our jobs. And that is a concern if you're a legislator, and I'm having trouble seeing why that's, you know, we need to take that chance.
So I think a few answers to that, Your Honor. I think first, I think the state does have an interest in considering past convictions, and that's what it did until 2019 with the law that's still in the books that allows them to conduct an individualized determination and analyze whether the person in front of them who's applying is safe to practice social work, and they can consider the past convictions.
How foolproof is that?
Well, there's no evidence in the record that there's any issues with that. We know the licensing authority didn't see any reason for this law, and so I think there's nothing in the record that there's any problem.
But I mean, you know, you read the paper the same as I do. This happens all the time, and you know, it's a big country. There are hundreds of thousands of people going through the justice system and the immigration system, all that stuff. It doesn't take many people to sneak through before there end up being severe consequences, because then, you know, we just shut down the whole system completely. We send everybody to jail. We don't do any probation. I mean, the risk is a few bad cases end up ruining what would seem to you and me like a reasonable system, but that's because we're lawyers and we are used to people arguing these things out. Why is it we should take the risk of the blowback that's gonna happen if something bad happens.
Well, I don't think there is a foolproof system, Your Honor, and I think that right now we're looking at.
That's my point.
I think right now we're looking at what's in the petition, and we allege that people with these past convictions are no more likely to commit crimes today when their convictions were decades ago than anyone else who doesn't have these convictions. And I think that, again, that individualized system is the way to weed out people who might be more likely to commit crimes versus people who aren't as likely to commit crimes.
How did the individualized system work?
So they can consider certain convictions if you
Is
have.
it on paper? Is it you meet these people? What do you do?
I believe that it's up to the licensing board, and they can do a hearing, they can do it on paper, they consider letters of recommendation, they consider testimony. The triggering, what triggers that system is having a list of past convictions. And so Catherine and Tammy aren't asking for the court to just give them their licenses. They're just asking for an opportunity to go in front of the licensing board and for the licensing board to look at their long history of rehabilitation. They each have many letters of recommendation, talking about how they are uniquely gifted social workers, how their past experience overcoming addiction actually helps them with helping their clients because they've been there before. And so I think what we see is that in some cases, people who do have a more difficult past are actually maybe more qualified to be social workers, and that's for the licensing board to determine.
But I guess my question is, I mean, on a personal level, I don't disagree as far as if you have someone who's had a substance abuse problem and committed violence during that and is now in recovery for 20 years, they make a great social worker. But I'm not in the legislature, and this is about a constitutional question about a statute they passed. So how do we get to Patel? I guess that's my real question. Is this truly an economic regulation, or is this purely a professional licensing type case where it seems to me even if there is a liberty interest, it's not as easy as saying there's a liberty interest to pursue your chosen profession, because we all know, especially those of us on this half of the room, we wouldn't be lawyers if we hadn't gone to law school and passed the bar and passed the character and fitness and all those kind of things. So how do we get to the economic and to Patel?
I think the bar is a good example, Your Honor. We're not challenging any of those qualifications. They have master's degrees, they pass the licensing exam, but with the bar, it's an individualized determination. There's not a flat ban. They consider your character and fitness, they consider people submitting recommendations on your behalf, and that's the same system that Texas had for social workers through 2019. And so I think that what Patel tells us is that when there are restrictions on your ability to work in a common lawful occupation, those restrictions have to be reasonable. And Patel sets out the test for that. And as my friend on the other side said, there's two ways we can look at that. We can look at whether the purpose, comparing the purpose to the government's interest, and we can look at the real world effect on the challenging party. That's what Patel says, that we look at the real world effect on Catherine and Tammy, where you're challenging that. And we compare the actual effect of the law to the government's interest. I think here we see that there is no government interest in excluding people who would pass that individualized determination, because we already have a system that we know the licensing board can exclude people who are not fit to be social workers. And there's nothing in the record that says that that was an inadequate system. And our allegations in the complaint, which is in the petition, which is all that we have now, explain that there was no issue with that. And when we're comparing the real world effect there, we see that this is a solution in search of a problem.
Well, do we have to go with you that far to answer the question that's in front of us of whether, this is appropriate for resolution on a plea to the jurisdiction, or is that something that we would look at more at a summary judgment stage once there's a little bit more meat on the bones? Because to me, it seems like there's a difference between saying, that's an interesting constitutional argument, but maybe I don't agree with it, versus, you don't even get in the courthouse door to assert it. So.
I think that's exactly right, Your Honor. What we're looking at right now is whether these are claims that are facially valid. To use Patel's language, we're looking for a basic pleading defect. Because as Patel explained, sovereign immunity, which is the only defect in jurisdiction the state has alleged here, is inapplicable to cases like ours that are challenging the constitutionality of a statute and seeking only equitable relief. And the only recognized exception to that is that basic pleading defect standard. And what we see there, and what this court has done in the wake of Patel, is we don't dive fully into the merits and resolve these open constitutional questions. What this court said earlier this year in the San Marcos decision is that on a plea of the jurisdiction, we, quote, delve no further than necessary into the merits to dispel notions that the plaintiff's claim is implausible. I think, and the court contrasted that with the deeper review that we might be doing.
So this is just implausibility at this stage?
Exactly. And I think what we see from Patel is that these claims aren't only valid and plausible, they can actually win on the merits, challenging licensing restrictions for health and safety, just like we're doing here.
So would you say, I mean, I have not committed myself to a position on the merits, but would you say there's a difference between implausible and unlikely to win? Is there some degree of, I mean, this may be angels dancing on the head of a pin, but
I think there is. I think that's what Patel has said. I think that's what this court has said. The Patel court said that claims must merely be properly pleaded, not viable on their merits to negate immunity. This court said there's a difference between the plausibility standard, where we're only looking at the merits a little bit and diving deeper into it, and in the Austin Appellate Court in 2020, in the Texas Department of Insurance case that we cite in our brief, explained there that even if the court found that the merits factors, quote, weigh in favor of concluding that the statutes as written are constitutional, this would not make the plaintiff's constitutional UDJA claim unviable in our jurisdictional inquiry. Rather, this would go to the claim's merits, which we generally do not reach on a plea of the jurisdiction. I think that sets the line pretty clearly, even if. Sorry,
is it unconstitutional to say you have to be 18? I used to give a lot of graduation speeches, and so you have to be 18 to vote, serve on a jury, hold public office, be an air conditioning contractor, cab driver, pharmacist, real estate broker, you know. Is that all unconstitutional? Because you can't, I mean, there's 17 and a half that could be a reasonable air conditioning contractor. How far is this going to go?
Well, I think
what things can I say, the legislature says, as a matter of law, 18 is it. That's all there is to it. Or a high school diploma is it, and that's all. So how do we stop? How do we distinguish that from, committed to serious felony?
Well, I think the easiest way to look at that, Your Honor, is that Patel says that we're looking at the burden of the law, and that in Catherine Tammy's case, that's a permanent lifetime ban. If someone's 17 and a half, that's only a 6-month ban on them practicing, and that would be a much lesser.
Try telling that to a 16-year-old.
Well, from our perspective, we can see that's certainly a lesser ban. And I think that there are cases where the state can draw lines. It just has to draw them more finely. There's another part of the ban that we're not challenging, where they drew a much sharper distinction. They said that people who have certain serious crimes that they committed against their clients while licensed, that gives them a ban. That's a much sharper and more tailored distinction. And we look around the country, looking at other cases that have struck down broad felony bans like this. That's the distinction that we see, that if the legislature has one of these permanent bans, that it has to draw the lines much more narrowly and much more close to the occupation that's being licensed. That's not what we see in the part of the ban that we're challenging here.
And I'm still trying to figure out when Patel applies and when doesn't apply. And I take it you're familiar with the Sonnenschein case in the third court, the law. Why wouldn't Patel apply there if we accept your arguments that Patel applies here? What's the difference?
I think the Sonnenschein case didn't get into depth on why Patel wouldn't apply there. And I think that ultimately we have to look at the Texas Supreme Court. And they haven't set that boundary. I think that it's possible that there are some boundaries they could set down the road about what occupations are covered by that. But what we know right now is there's a long history of the due course of the law of the land clause protecting the right to pursue a common or lawful occupation. We go through the history in our brief. And I think that it's the Crown case gives us an example of what the outer limits of that might be. Is that in the Crown case, it was about the right to sell smokable hemp. And there the court said that, well, illegal occupations that are, quote, inherently vicious are outside that. But I think that within that realm of occupations that aren't inherently vicious or illegal, that's where the Patel test applies. And that's where we're looking at whether the restrictions that are applied are reasonable. And the Patel court explained there is deference to the legislature there. But for a constitutional challenge, the deference is constrained. We have to take a hard look. And what the court said is that requires looking at the evidence. I think that gives us an indication, as Your Honor mentioned, that that's really a question for down the road, for not at the pleading stage, but at the summary judgment stage.
And can you help me with how many people does this involve? How many people used to get individualized determination? How many people are applying in a year for licenses?
We don't know, Your Honor, because there's nothing in the record about that yet. We're still at the pleading stage.
I
We haven't
bet it's
discovered.
out there somewhere. If somebody could look that up, it would save me having to do it.
We can certainly
Just
take a look,
send us
Your
a
Honor.
letter, if you would, yeah. There's bound to be some kind of government report on it.
I think ultimately the only person who would know that would be the licensing board. But it's also possible there's people who simply aren't applying because they found out about the law, and even if they
Is
have.
that something we could get from, out of discovery from the licensing board? If this case
I
went
think
to
that's certainly, they would at least know who has applied and who they've had to deny because of the ban, which is what happened with Catherine and Tammy. They of course wouldn't know people who didn't apply.
And there's nothing short of a license, they can be a counselor at, I suppose, a church, a nonprofit organization, something like that. Maybe they can't prescribe things and diagnose things, et cetera. But as far as the heart of what you do, which is helping people work through their problems and get better, they can do that.
So what the law says is that to call yourself a social worker, to tell people that
They don't need, again, to call yourself a lawyer, you gotta do this and that and the other, but that doesn't mean every guy in the prison that's telling people how to file stuff isn't practicing law. He's just not calling himself a lawyer. So can you practically do what you feel like your calling is and what you're gifted to do, and without having the certificate?
I think the best answer to that is no, Your Honor. And there's certainly other ways that they can help people with problems, but their training that they have a bachelor's and master's degree is using social work. And what the state law says is that using the methodologies of social work and counseling, that's the licensed practice of social work, and you need a license to do that. And so, while of course they or anyone else could help people in other ways, they can't do what they are called to do and what they spent years training to do, which is help people through the methodologies that they learned through their degrees.
What are we being asked to decide that's not a pure question of law?
I think the only question that you have to decide right now is whether there's jurisdiction, Your Honor. I think that's a very easy question under this court's precedent.
And
But
that's
what
plausibility,
facts-
right?
That's plausibility. This is a plausible claim, a valid claim. The courts have used slightly different language, but it all gets to the same thing.
But what facts would we need to decide the question of law presented to us?
I don't think you need any facts to decide that plausibility standard. I think to resolve the actual constitutional claim, we would need discovery on the purposes of the law, whether or not there was a problem. Right now, all we know is that the licensing authority has said they don't know why the law was passed. And so there's no evidence on the record of why this law was passed, whether there was a need, and I think that's what would resolve the constitutional
So a
claim.
valid claim doesn't mean a winning claim.
That's correct, Your Honor, and that's what the Austin court said in the Texas Department of Insurance case, that even if the court thinks that the claim would ultimately fail and that the statute would be found constitutional, that's still not the question we're looking at right now. So I don't think you'd have to dive into any of the facts at this stage. Well, unless you have any other questions, I'd be happy to go through
Anything
more.
else? Thank you very much, Mr. Knight.
Thank you.
Ms. Glusman?
Before you get started, could I ask you the same question I asked opposing counsel? Is there a distinction between implausible and unlikely to win? And if so, where does that?
Well, I guess my answer would be neither of those is the legal standard this court should apply. The standard is whether or not the claim is facially invalid, not whether it sounds like it might win someday. The court actually, if you look at what Patel cited Andrade. And Andrade said, if you don't plead a facially valid claim, sovereign immunity bars this. And then it went through and did an equal protection analysis.
But does facially valid mean likely to win, or how do you describe facially valid?
I would define it kind of, if I could just borrow from like a 12b6 context. If you read it and legally the claim will fail no matter if you accept all of their facts as true and the claim still fails as a matter of law, it is facially invalid. And so, again, the Texas Supreme Court has done pretty much a merits analysis in Andrade, in Klum.
Is that any different than what we said in San Marcos?
I don't think so, Your Honor. I mean, this court in Erickson said you can't just name a constitutional provision and move forward. I would also say, the Texas Supreme Court's case in Villarreal. I mean, in Villarreal, it was a academic dismissal, and they pointed to a previous case that said, well, disciplinary dismissals get me procedural due process. And the court said, that's nice, this is an academic dismissal. You haven't waived sovereign immunity because that is not a constitutionally protected interest in this case. So there is actually a very significant consideration of the merits of their claim. It's not just whether or not it sounds plausible. So it is whether or not it would be facially invalid as pleaded. Now, if it is, and to be clear, that doesn't mean they have to prove they'd win. Again, if there are fact questions that remain out there, that if they succeeded on those fact questions would mean they win, then yes, that does get to go forward. But if we accept all their facts and they still don't win, that's facially invalid and the claim should be dismissed.
How do we do a rational basis test or a Patel test if we have no facts in the record showing us why the legislature did what they did?
Well, the rational basis test is not based on record facts. The Texas Supreme Court has kind of made that clear. If I came up with a reason just standing here today, that would be sufficient under the rational basis test, so you don't need facts for that. We do have, again, just a little bit of legislative history on the idea that the legislature did think that some healthcare professionals had misused their licenses and injured people, and so that's what we have.
I guess that's a better way of asking my question would be, in light of that case, I'll be honest, that case made no sense to me because, easy for me to say because I didn't have to decide it, but you can always come up with a theoretical reason for what the legislature does.
Yes.
Right? So it seems to me that's no standard at all. It's basically whoever's sitting there writing the opinion gets to decide what the legislature must have been thinking they did it. So how do we do that?
I mean, it is designed to be a very, very forgiving standard to the legislature because that is the constitutional structure. The legislature decides what is best, and the court only interferes if it is unconstitutional, and that's a high standard when it comes to deciding.
In Patel, nobody argued that there was nobody could come up with a reason for why you had to do 750 hours of CPR to be an eyebrow threader. Even someone as smart, as able as you, Ms. Glisman, could not come up with some argument in that case. I certainly couldn't.
Our office tried, Your Honor, but obviously.
There are cases where nobody in their right mind can come up for a good reason. This isn't that case.
And I would agree with that. I think there is a rational basis for this law, and I think it would survive under that test. I think it would also survive under Patel because, again, there is not an improper purpose for this law. And as we've discussed, there are many ways that the plaintiffs can help others in the healthcare field without having this specific license. And so,
was there anybody say, we have to do discovery first, or any ruling on discovery, or nobody requested discovery, or we're gonna do the plea to the jurisdiction first?
I think you saw the basic arguments here, which was we filed a plea to the jurisdiction, and they said what we have pleaded is sufficient. And then they wish to go to discovery. I don't think that's a reason they necessarily oppose the plea. They just believe that they have pleaded what was sufficient, and that discovery would then supplement their claim. So that is where that was. We didn't get to procedural due course or equal protection. I don't know if you had any questions about those, but I think just let me.
Well, has anybody poked a hole in a thought if the deal is nobody, no how, with this kind of conviction can get a license, and the legislature says that is procedural due process, is there any qualifications or exemptions from that rule?
That it is a flat ban in this case. There's no discretion for the board to create an exception.
So it's just if that is irrational, is the only question.
That would be the substantive due course question. The procedural due course question, if I could just do that real quickly. They get adjudicative process to determine whether they meet the standards, and then they get legislative process to determine what those standards are. So they got a hearing and everything that they wanted to determine whether they met the standards, and they did not. Their argument is about the substance of those standards, and so legislative process is what covers that.
Thank you.
Thank you.
Anything further? Case will be submitted. The marshal will now adjourn the court.